Role of judiciary harmonizing fundamental rights and the directive principle of the state policy. It has been held the fundamental rights and directive principles are the two wheels of the chariot designed to make the social economic democracy true. It is significant note that among the several articles inside in Article 4th of Indian Constitution, Article 45 has been given the such importance as education is the basic necessity of the democracy and the people are denied their right of education, then the democracy will be paralyzed. And it was therefore emphasized that the objective inherent under Article 45 is part 4th of the Constitution should be achieved within the 10 years, and the adoption of the Constitution by establishing the obligation of the state, the founding fathers made is the responsibility of the future government for the formulated a government program in order to achieve the given goals, but the unresponsive and sluggish attitude of the government to achieve the objective inherent under Article 45 belied the hopes and aspirations of the people. However, the judiciary showed keen interest in providing free and compulsory education to all children below the age of 14 years. In the case of Moini Jain in the state of Karnataka 1992, the Supreme Court case number 666, the Honorable Supreme Court held that the right of education is a fundamental right inherent under the Article 21 of the Constitution. The right of education springs up from right to life. The right to life under Article 21 of dignity of the individual cannot be fully appreciated without the enjoyment of right of education. The Supreme Court observed the right of life is the compendious expression for all those rights which is the court must enforce because they are basic to dignified enjoyment of life, extending the full range of conduct which the individual is to free and pursue. The right to education flows directly from the right to life. The right to life under Article 21 and the dignity of an individual cannot be ensured unless accompanied by the right of education. The state government is under the obligation to make the endeavor to provide the educational facilities at all level of citizen. It is the in case of Unikrishnan JPB state of Andhra Pradesh 1993 as the Supreme Court, while examining the decision of Moini Jain case, party overruled the decision and rendered the Moini Jain case and held that the right of education implicit in the right of life, personal liberty guaranteed by Article 21 must be compared in the right of directives of principal state policy contained the Article 41, 45, 46. However, the limited to state obligation to provide the educational facilities in the follows. Every citizen of India, every citizen of country has the right to free education until the completeness of age of 14 years. Beyond that, the state, this right of education is the subject to limit of economic capacity of the state. Again, the Bandhwa Mukti Morcha, Union of India 1997, 10 SCC 549, K. Ramaswamy I and the Sagir Ahmed J. While observing that the illiteracy has many adverse effects in a democracy governed by a rule of law, here the educated citizen could be meaningfully exercise their political right, discharge social responsibility satisfactorily and develop a spirit of tolerance and reform. Therefore, the compulsory education is one of the essential for the stability of democracy, social integration and to eliminate social evil. The Supreme Court, the rightly harmoniously construing and provision of the part 3rd and 4th of Constitution has been made right to education a basic fundamental right. Under the backdrop of aforementioned declaration by the Supreme Court of India, the Government of India Constitution 86th Amendment Act 2002 has added a new article 21A, which provides that the state shall be provide free and compulsory education to all children at the age of 6 and 14 years in such manner as the state may by law determine. The further they strengthen Article 21A, adding the clause 51A, which provides for those who are the parent of the guardian to provide appropriate opportunity for education to his her child to a ward between the age of 6 and 14 years on the basis of constitutional mandate provided under Article 41, 45, 46, 21A and 51AK. The various judgment of the Supreme Court in India, both the Government of India as well as Supreme Court of India has taken several steps to eradicate illiteracy, improve the quality of education and simultaneously ensure that the school dropout are brought to nil. Some of these programs are the National Technology Mission, District Primary Education Program, and nutritional support for primary education, National Open School, Midday Meal Scheme, Sarva Shiksha Abhiyan, and other specific initiatives. Beside this, several state enacted legislature provide a free and compulsory primary education, such as the Right of Children to Free and Compulsory Education Act 2009, the Kerala Education Act 1958, the Punjab Primary Education Act 1960, Gujarat Compulsory Primary Education Act 1961, UP Basic Education Act 1972, Rajasthan Primary Education Act 1964, Tamil Nadu Right to Education Free and Compulsory Education Rules 2011. The integrative approach toward the fundamental right directive principles, such as the both should be interpreted and treated together as fundamental rights along with the directive principles, such view that define the scope of ambit of former. For the most part, directive principles have been used to broaden and the give depth of some fundamental right and to imply some more right therein the people over the above the expressly state the fundamental right. The Supreme Court of India National Legal Services Authority Union of India observed, speaking for the vision of founding fathers Rangnath Reddy, the Supreme Court speaking for the Justice Krishna observed, the social philosophy of the Constitution shapes creative judicial vision and the orientation of the nation has the dynamic doctrine economic democracy sense which political democracy chemical we say too because our constitution in parts of third and fourth as elsewhere in souls such as the value system, and the debate in this case puts precisely the soul and peril. Our thesis is that the dialects of social justice should not be missed in the synthesis of the part third and fourth is to influence state action for pronouncement. Constitutional problem cannot be studied in a socio-economic vacuum, since socio-cultural changes are the sources of the new values and the slugging of old legal thought in parts of process new equity loaded legality. The ages of social scientists in this role of constitutional invigilator and fails the functionality is the forget of dimension in the complex duty. While interpreting Article 21, the Supreme Court has incorporated such the diverse aspect as the children in jail entitled to special treatment. Sheila March versus Union of India 1996. 596 health hazard due to pollutions. Bigger interest in housing, Kalidasan state, health hazards and harmful drugs, right to speedy trials, and cuffing of the prisoner, delay in execution of the detailed instant and immediate medical injured person from Katara, starvation of death to now, Reliance Petrochemical Limited Indian Express, right to open trial, inhumane condition, aftercare home. The most remarkable feature of the expression article is many of the non-judicial directives, principles embodied in Part 4 of the Constitution have now discorrelated for enforcement fundamental right by magic wand of judicial activism, playing on Article 21 EGA, right to pollution-free water, air, Subhash Kumar State of Bihar, right to reasonable resignation, Shanti Star Builder and Narayan, Kamla Totane, right to food, clothing, decent environment, ever protection, cultural heritage, Ram Saran, Parsi Union, right to every child of full development, Shanti Star Builder and Narayan Thampe, right to residence, hilly areas, process of road, state of Medgaon, Kanna, right to education, but not for the professional degree.